Welcome to LegalEase on Me. I'm your host, Malia, and today we're going to talk about things that make the complicated legal stuff simple and easy to understand. Specifically, we're talking about intellectual property. If you've been watching or listening to my show, you know that intellectual property is one of the things that I focus on, I specialize in my practice. But I have the guru, the master, the expert from the Plus, let me say it right, Plus
IP firm, the Plus IP
Plus
firm.
IP firm, Derek Fahey. And he's joining me today. And Derek, take a second just to introduce yourself and talk a little bit about what you do.
Okay, great. Well, thanks for having me. Super pumped to be in this studio. I love the space. And I'm an intellectual property and a registered patent attorney. So I help people monetize and protect their ideas and inventions. And we do that through intellectual property, like patents, trademarks, and copyrights. And my background's in engineering, and our practice is focused exclusively in intellectual property. Yeah.
Thank you, Derek. And you just said something in your introduction that I want to make sure that people understand, because I am not a patent attorney, and nor can I be. And I don't think that people understand the difference, just sort of more broadly between patents, trademarks, and copyrights, but then about how the legal professionals cover those areas. Can you talk a little bit about that?
Sure. So intellectual property covers different subsets of law. So you have patents, which protect inventions. You have trademarks, which protect brands. And then you have copyrights, which protect music and artwork and photographs and tattoos if you wanted to. And as a patent attorney, you have to take a second bar exam known as a patent bar to learn all these, really strange rules that the patent office has. And you have to have an engineering or science background. So technically you could become a patent attorney if you really wanted to, but you have to have a science or engineering background. So if you wanted to go back to school and become an engineer or a biologist, you could become a patent attorney eventually.
So I'm going to say it again. I am not a patent attorney, nor will I be qualifying myself as one, because I'm not going back to school. And the thought of taking another bar exam, especially a science-based exam, really makes me want to die.
Okay.
And I'm sorry, no
That's
offense,
okay.
but seriously, patents require a lot of skill and expertise in the science and engineering area. And not all of us are qualified nor equipped to be doing it. So that is not my practice area. I don't do that. But I love having you as a partner that I can send all of the people who keep asking me about patents for products, other inventions,
software,
all of my software folks. Derek at the Plus IP firm, they have the capability to help you get your software patented, all of your inventions and things like that. So I wanted to draw that distinction because I think that's one of the areas in IP that the everyday person doesn't understand, that, all things are not created equal in the area of IP. And certainly the distinction between what we cover is an important one. So welcome to LegalEase on Me. I'm so happy to have you in the studio.
Am I the first one?
Yes, you are. You are my first guest.
Oh my gosh,
well, I'll take that
so
back.
exciting.
I've had one other guest, but not another lawyer. I had a business owner to come on, but you are certainly the first colleague that I brought on to, help make the complex legal stuff easy for the people.
Hey, well, thank you. Thank you for that. That's fun. Yeah.
No, I'm so happy to have you. And speaking of the complexities, my first question for you is, what do you think with respect to IP being the importance of IP to content creators and social media influencers?
Yeah. I think now with the internet, I think that, in my opinion, intellectual property is more important than ever. And the reason why I think that is, and I'm not sure if you have this same feeling, but the internet has made it a lot easier for people to produce content, to disseminate content, to sell products and services online, and has created this whole new ecosystem. And it's awesome for creators and people that are creating things. However, on the other side, people make it that, the internet also makes it so much easier for people to steal ideas. And the idea of intellectual property I like to say intellectual property is a concept that if you make and create cool, unique stuff, you should own the rights to it.
Yes.
Right? So
couldn't agree more.
When people see cool stuff, the bad actors may want to take it. They may say, hey, that's a great idea. I want to do something like that. And that's not okay for IP. That's what you have to do. So you have to protect your IP for creators,
That's right. And I think you're exactly right. We are sharing more openly, faster, more of the details over social media. And with that comes risks. And, as I like to say this, every business owner may not be a creator necessarily, but every creator is certainly a business owner. And whether you know it or not, whether you've formally registered a business, whether you've formally filed an application for a patent or a trademark or to register a copyright, but you have a responsibility to protect that which you are creating, like a business, right? Thinking like a business with respect to making sure that you are not diluting the value of your intellectual property by not protecting it, allowing people to come in and playing loosey-goosey with that. And I don't think people understand that, if I'm a creator and in my content creation, I'm doing something unique, I'm doing something novel, I'm doing something that hasn't been done before, and I'm sharing that, and I'm not protecting that, I am, again, diminishing the value of my overall sort of intellectual property portfolio, but my business and my brand. And so being able to come to the table when you have formalized your business to say, this is part of the value that you can assess to determine what my business is worth, that's another great reason to lock that down. Can you talk a little bit about that?
Yeah. So, if you're a content creator, intellectual property is probably the top assets you own in your business. Maybe you may have equipment like you have in this room, you may have an asset, but intellectual property is probably going to be the value that your business, the vast majority of the value of your business. And the way to protect that intellectual property is through the intellectual property laws like you and I work with, whether it's trademark or copyright or trade secret. We haven't talked about trade secrets yet, right? That's a big deal in both our practices. And if you don't keep that asset protected, you could lose it. There's certain things you need to know whether or not you can and cannot do. And if you don't do, it's more about what you don't do as opposed to what you do as well. You can actually not doing something in a timely fashion can actually lose all the value to that asset.
Let's give an example of that.
Okay.
What example? Give one example of how that could work out and be detrimental.
Okay. Something super simple. Okay. Let's talk about like your mom's secret recipe, right? You're making this amazing cookie recipe and, you put it on TikTok and you're explaining everything.
Are you guys listening to this?
And you're explaining here is the secret recipe. You put it all over. And now people may love your cookies, but now everybody else knows how to make these cookies. Okay. Now maybe there is something you can leave out to make it not disclose everything, but that little thing you need to protect. And what's a secret? You got to keep it secret. You got to take reasonable measures. For example, Coca-Cola is probably the biggest and most well-known, trade secret. Not every, in Coca-Cola, I don't believe that any single person knows the entire
full
recipe. Okay?
And we're talking about people that work even within the company, right?
Yeah. No, I don't think anybody knows.
Right. So listen to what he's saying. We're not even talking about sort of disseminating information to the public. We're talking about the need within your own camp to keep recipes and formulas secret.
Yeah. Operations, different things, customer lists. Okay. That's a big one as well.
Yep.
If you're bringing on employees and independent contractors, not making sure that they know that they have to keep it secret. And also maybe they don't have to have all that information. Maybe there's certain things you can actually limit access to. Maybe it's digital access with passwords or having non-disclosure agreements with penalties if things are disclosed. That's super important and
Yeah.
super valuable. That's sometimes trade secrets. In the case of Coca-Cola, that's their biggest asset. I mean,
Yeah.
besides their land, but that's a big asset.
So to sort of bring this home, because remember, so what we're doing is because we know, listen, people hear intellectual property and they either go to sleep or get so afraid they run in the opposite direction. So what we're trying to do is make it easy enough so the everyday person can understand it. So when we talk about Coca-Cola, for example, and the fact that not one person likely knows the entire recipe from end to end, what sort of benefit does that give a brand like Coca-Cola in terms of not then being able to fight off other challenges from folks that are trying to get access to that?
Yeah. So if you take reasonable measures to keep your information a trade secret, now you have a competitive advantage, right? Case in point, Pepsi. I mean, if you're from the South, you probably are familiar with the rivalry between Coke and Pepsi.
Yes.
Okay. But they have, Coca-Cola was the first to market, and they have this recipe that everybody loves. Now, that's a competitive advantage. If you don't keep that secret, and if Pepsi somehow gets that secret, now you have all these people that are now doing the exact same thing that you're doing. And to your point earlier, it dilutes what you're trying to do, right?
Yep.
And that dilution is just going to basically totally destroy the value.
Yeah, and then, when we start then talking about fighting it out in court, right? So say, for example, Pepsi gets access to it and they create a formula, substantially similar to it. They look at things like how well you've protected the trade secret to determine whether or not Pepsi has really infringed upon your intellectual property. So what you do in-house helps build a case against infringers.
Yes. And it's not everybody needs to be a Coca-Cola. Not everybody has to have these huge silos preventing people from doing it. But, don't leave the recipe on the table.
Yes.
Don't disclose the entire recipe on TikTok and Facebook and Instagram, right?
Guys listening?
Don't do that. I mean, don't, customer lists, limit access to that. Maybe password protect files so who can actually have access to it. Maybe if you have a special spice, again, I'm just talking about the cookies, right?
But all of this is really pertinent to this TikTok audience specifically because you see it all day, every day.
Right?
This is the recipe. And I love the open sharing. I mean, that's one thing I love about TikTok over the other apps is that people are willing to educate and to share. But I want you to be mindful of what Derek is saying, that when you do that, you might be sort of diminishing your ability to argue later that you didn't mean to share that to the point that people are then now taking it and using it and commercializing it.
Right. Keywords, secret. Got to keep it a secret. I mean, it's pretty much what it says, right? It's got to be kept a secret. What are you doing? Are you putting it in a safe? Maybe if you're doing with recipes or cookies, you can have the bag of spices already pre-made, and then your employees or your colleagues or whoever's doing the spicing can just measure it out and use it, as opposed to telling them, go buy, allspice, cinnamon, or my secret recipe is turmeric or whatever the secret recipe or secret spice is. So I think that's really important, and people really undervalue the trade secrets, and you need to have the right agreements in place to make sure that those are kept secret.
All right. Now he said agreements. So you know how I love my agreements. What are some of the agreements that are important for, we've talked a little bit about confidentiality agreements, non-disclosure agreements. Are there any other agreements that a creator, an influencer, a small business that, wants to share and connect with customers and clients over social media or other digital media platforms? What are some of the agreements they should be thinking about getting in place?
Okay. So I think one of the most important ones, is if you're working with independent contractors, even employees, you need to make sure that what's being created is owned by the business. In intellectual property law, depending on what type of intellectual property it is, whether it's patents or trademarks or copyrights, the person that's actually creating it could own the rights to it. So for example, if someone is writing sheet music for you, just because you hire them may not mean you actually, that you actually own it. Okay. So
really?
Yeah.
Derek, all these people hiring giggers on Fiverr and Upwork.
That's right.
To do things. Do you mean that they may be paying their money to get
That's right.
things and they don't actually own it?
Oh man,
Oh
this
my
happens.
gosh.
That happens so often. Photography. So if you hire a photographer to take some photos of you, technically, if they're an independent contractor, they probably own that photograph, unless you get them to transfer in an agreement in writing the rights to you. And most times they are willing to do that if you handle it up front. And if you tell them, hey, I'm owning all the copyrights to this, typically they'll say, sure, I just would have the opportunity to be able to say that I, put this in my portfolio. That's very, very typical.
To use it for promotional purposes, marketing, but they shouldn't have an interest outside of that and owning it. But some have gotten really
slick,
sophisticated.
Yeah, I'll call them slick.
Yes, and they are now upcharging to transfer the copyright interest to you, the person that's actually paying for it. But the point is, you want to work that out before entering into these arrangements with these independent contractors or third parties. Now, when people are creating for your business, if they are an employee, then
it's different.
It's different, right? Because everything that is created in the context of an employment relationship is owned by the business.
Yes. In most instances. Actually, in patents is a bit different. So patents even if an employee is creating, let's say you have a product development company and you create this cool, cool invention, the employee actually owns the rights to any potential patent rights to it, unless the employee signs a document that says, I'm going to transfer the rights of the business. Generally speaking, they come to you to have an employment agreement that says, hey, I'm hiring you, that says the employer is hiring the employee and they're going to transfer all the intellectual property. And I like having cooperation provisions in there that says, hey, not only am I going to transfer the rights, is that how if I leave and for any reason, I'm still going to sign documents if you need me to. I'm going to cooperate as an employee with you to actually transfer those rights and perfect those rights if needed. That's a huge deal. That's a huge deal.
That's important when you think about, which most business owners have an exit strategy, right? You're thinking about growing your business to a point where you can sell it. Right? Any buyer of your business is going to want to see that, right? If there is an invention that is a significant part of what makes the business valuable, they want to see that the inventor is going to cooperate, not going to come back later and claim ownership, right? And so I think getting those things early, documented up front, that will save you a pound of pain later.
Oh my gosh. I have actually experienced a horror story from a client.
Okay, thank you, because I was going to ask you, give me an example, a horror story of where things have gone wrong.
I have a horror story that's actually a true story, somewhat true. I actually wrote a story based upon this actual fact pattern. But essentially, here's a story, okay? True story. We'll call him Tom. Tom is the owner, okay? We'll call him, let's call him Owen. Owen the owner goes and hires Edward the employee.
Yeah.
And he says, hey, Edward, I want you to develop this type of technology. I'm not even going to tell you what type of technology it is, but it's a very sophisticated type of technology. Please create this. And, we're gonna work together and we're gonna make a lot of money.
I'm in.
Okay, you're in, right? You're in. You start developing it. And you come to me and you say, hey, Edward owner, I have a great idea. Let's file some patents. Says, oh yeah, we got a great idea. Let's do it. Starts filing patents. We'll call it, okay, you go to the attorney, you hire the attorney. I'm paying for the attorney's fees. We're getting patents. And then a couple of years go by, you have all these patents all over the world. We spend a lot of money on this, okay? You come to me and say, okay, well, now I want a piece of the pie. I own all the intellectual property. I, the employee, own all the intellectual property. And how can we negotiate where I have a bigger piece of the pie of your company? Edward, the owner, says, wait a second. I paid all the fees. You don't own anything. What happened was the employee, with the attorney, they actually, instead of assigning the rights over, he just conveniently forgot to assign any rights. And he, as the inventor, was on the as a first named inventor.
Oh my gosh.
And the owner actually was paying all the fees, and he got the patents. The employee got the patents.
Wow.
Probably about $500,000 in attorney's fees. Now that's a malpractice issue for the attorney. But now, if you're trying to raise capital to get some funding to go and actually produce a product, now you got an ownership issue.
Yeah.
And how are you going to, if the first thing a venture capital person is going to ask is, well, where are all the documents that say I own all the IP or you own all the IP?
That's it.
And now, yes, he can go and fight this and say this was fraud and malpractice and all this other stuff.
For another $500,000.
For another $500,000, right? So these are things that, like, you got to pay attention. You got to, as an owner, you really have to say, hey, even if you have an attorney, you have to be asking, like, okay, do I own the IP? Who owns the IP? You need to be thinking about that, especially when it's your biggest asset. It's like having a house and saying no, that I don't really own the house. It's pretty nuts. But that's a big horror story.
Oh, that is a horror story. And in that, you said something else I want to touch on, because I think we often talk to people about their intellectual property, from a defensive perspective, right? And that's important. Brand protection is important. Everything we've talked about from a sort of a strategic defense is important. But you talked about being able to use intangible assets to raise capital.
Yes.
And I don't think that people understand that. That, yes, you have your tangible assets, your mics, your equipment, your fleet of cars or whatever that are part of your business that can be collateral for loans, but your intangible property as well can be used as collateral. Can you talk a little bit about that?
The second richest man in the world is the owner, as one of the founder of LVMH. And LVMH is all branding.
Yes.
Okay. And intellectual property assets are just like any other piece of asset. It's a thought, right? And an intellectual property asset, it's just like a house or a car. Anything you can do with a car, you can probably do with intellectual property. You can buy it, you can sell it, you can lease it out, you can get a loan against it. In fact, when, a lot of times if you go to a bank and get a loan, the bank will actually record a security interest, which is a document that says, I own a right to this intellectual property if something happens. So if a litigation happened or anything happened in bankruptcy, they would actually have a right to security interest on that particular asset, whether it's a trademark or a brand. So it's a huge, huge deal. You can use intellectual property to raise funding, because now they actually have an asset to show, hey, I own this right, and you can defend it, you can sell it. So just like a house or a car.
So as a part of your business strategy, it's making sure that you do own it, right?
Yeah.
I mean, and let me be clear, you may own it because you created it, but being able to prove that up and have something that you can demonstrate and show that it is documented that you are the owner and that you have the right to fend off infringers and challengers. That's a different story. So taking that extra step is so important to be able to actually use the intangible assets that you have.
Yep. In fact, every single office, the copyright office, the trademark office, the patent office, you can go and look at the registered copyrights, trademarks, and patents and see the chain of title, just like you could with your house.
Yeah.
You can actually, you can go and see who owns it, who has a security interest in it. You can see, okay, JP Morgan Chase owns this asset. And the first thing, whenever you have a sale of a business, the first thing the attorneys are going to do in the doc room is they're going to say, okay, give me all your assignment, give me all your ownership documents so we can see what IP assets that you have. And they will go through with a fine tooth comb and say, who owns this? How do we know this? How can we prove this? Because they want to know what they're buying, right? So whenever you do a sale or some sort of transaction, sophisticated attorneys are going to ask for those kind of documents. And you should be thinking that long-term. I think there's an expression that says, whenever you're running your business, try to plan like you're going to be exiting.
Yes.
Right. So you need to have that information ready to go. So you can say, here's all my ownership documents. You can review it. You can look at the chain of title stuff. It's so important.
And we touched on it a little bit, but what are some of the risks that may present themselves when you show up to the table and you're not able to do this? What is it that an investor or a bank, what are they fending off?
Yes. Okay. That's a great question. It's like you can have your business is like, imagine she's a beauty queen. Okay.
Okay.
And now, there's nothing's gonna be perfect, right? Everybody's got some blemishes, right? And once there's the attorney's job is to really look at this beauty queen and say, okay, or maybe that's a bad example. Yes.
No, it's a good. Let's go with it. Let's go.
Okay. So the job is to say, well, I did eyelash. It's tweaked the wrong way, right? When you don't have your ownership interest documents all ready to go and your files are a mess, you start having warts, right? So, maybe there's a lawsuit pending. That's one wart, there's an ex-employee that's saying it's, discrimination or employee discrimination. It's another wart. Maybe there's, they bought some land that has some environmental issues. That's another wart. And then it comes to the assets that everything's based upon, and then they don't even own it. And now eventually you have enough warts. They may be able to fix some of them, but the more warts they have, they may just not want to continue the transaction. So
because they're buying your issues.
They're buying your issues.
Yeah.
Right. So, and they're going to find it, they're going to find, if you don't disclose it, one, the attorney's job is to find the issues. Right.
Yeah.
And if they don't find it, if you lie on it when you do the transaction and you represent something that's not correct, they're going to come after you.
Yeah.
So. Yep.
That's great. I mean, you're so right. It's really just, and thinking about these things early, right? When you're small, my motto is plan big, plan big. So you might be small. You may just have started out. Maybe you have an idea and you're getting it off the ground. You're a startup of all startups, right? But in the beginning, you're planning to be big, right? And when I say big, I'm not necessarily talking about 1,000 employees and, multiple countries. I'm talking about bigger than you are today. To Derek's points, that one day you'll be able to, exit and sell your business and maybe move on to another business or retire or whatever it is. That's big. Your life plan is big. And you don't want to be sort of hamstrung at the end of that, right?
Mm-hmm.
You've grown, you've gotten to a place where it's like, yeah, I'm ready to move on, to find out that there's not as much value in the business as you may have thought because you haven't done the appropriate things early on.
So easy to prevent and so easy to do, right. I see there's like 5 or 6 things that small businesses can do that they could, it's just knowing what to pay attention to. It's almost just like paying attention.
Yeah.
You just have to know what to pay attention to. And the ownership issues is a big one. Another big one is, we touched on it earlier, is don't disclose too soon.
Yeah.
Right. Don't let the cat out of the bag just yet until you know if you can or not, so that's another big one as well.
Oh, that's great stuff. Now I want to talk a little bit about licensing, because I think this, especially for smaller businesses, creators and influencers, I think it's probably an anomaly, just a mystery, or a mystery, not an anomaly, a mystery about sort of how it all works. But I think one good example is Barbie.
Oh, yeah.
Oh, my gosh. We all just came out of, this Barbie craze.
Case in point, got the nice pink outfit on.
Yeah, I'm inspired.
Yeah.
But Barbie, they have done so much with their licensing that has almost superseded the product side of the business, right? They make so much money on being able to license out their intellectual property. Can you talk a little bit about that?
I believe they have, Mattel, who owns Barbie. Barbie has, I want to say, over 150 registered trademarks.
Yes. That's insane.
That's an asset. Those are all assets, right? And when you go to enforce a brand, you need to have something to enforce, right? And trademark registrations, which Barbie has plenty of, it makes it a lot easier to enforce. It has several advantages. It provides notice. It provides that you own the rights to it. It's been adjudicated that it's been examined. You own the rights to it. And, if you don't have a registered brand like Barbie, it's a great point. It may be more difficult to enforce. Registered trademark also have attorney's fees and costs. And it also gives, I think, a little more sense of professionalism to the company.
Yeah.
And so that how we're talking about, licensing, what are you going to license?
Yeah.
Right? What are you going to put on the piece of paper? Right? That gives you a registration. There's a lot of benefits. I mean, Barbie is such an amazing example.
Yeah. You have the dolls, that's one part of the business. And then you have the millions of brands that want to use Barbie.
Yeah.
For their as part of their business. And so they're paying Mattel to be able to use Barbie in different ways. You think about, from the movie to other products. And this brings me to another point, because I see this a lot, and I really want you guys to stop doing this.
Okay.
You cannot unilaterally decide that you have the right to take, I don't care how big the brand is, to take pictures and logos and slap it on t-shirts and slap it on other things that you're using for your business. You might have a fingernail polish line, and you want it to be a Barbie line, right? You want all of the shades of pink, and you want, the Barbie logo. You simply cannot do it unless you have secured a license to do so from Mattel, right? And if they are, in which I'm sure Mattel is aggressively monitoring.
Aggressively.
Right? The use of their marks. You're likely to get into trouble for that. So you just have to take care. And I know sometimes we're smaller businesses. We're just, slapping stuff up online. And, in fact, for my daughter's second birthday,
okay,
she loved Cocomelon. And my sister, in all of her lack of wisdom, like, I'm going to get her an outfit made. I wasn't thinking that she was going to get a Cocomelon outfit made.
Oh my gosh.
And so she sends me this box, and I open it up, and it's this jumpsuit with like a hand painted Cocomelon picture and Cocomelon. I'm like,
everybody loved it, right?
Yeah. I'm not going to say I didn't use it, but, I certainly was, a little more reserved about sort of where I posted it. And we weren't using it for commercial purposes, which, also makes it different, but it's still, you've got to be careful of things like that.
And then everybody loves it. And then people will come to you and say, wow, I have this great idea. I'm going to put Barbie on t-shirts and start selling them. No, you can't do that.
No, you absolutely cannot.
Funny you say that is, who else does that a lot is Jeep.
Ah, yeah.
Jeep. People love everything Jeep.
Yeah.
And Jeep has all these trade dress registrations. You can talk about that on the grill. And just putting the grill, the look of that famous grill shape.
Yeah.
Jeep will enforce the heck out of that.
The Coca-Cola bottle.
Oh, the shape. Yeah.
The shape.
Yeah.
When we talk about trade dress, it is sort of the design. So we're talking about the grilled Jeep, the Coca-Cola bottle. I mean, think of it like this. Things that, if the name was not on it, you would say, that's a Coca-Cola bottle.
That's right.
That's a Jeep grill, right? Mm-hmm. This is trade dress. And you've got to be careful when you're designing things, because we're all inspired, right? Mm-hmm. By things that we see. Yeah. You can't really avoid it. But you've got to, how can I say this simply so we can all understand? That's what the show is about. You've got to make sure that it is not substantially similar to what folks have already protected. They already own, right? In trade dress. Like, they've designed this in a way that is unique to their business.
Yep.
Right? And you've got to avoid copying those things.
Oh, definitely.
For your business.
Yeah. If a great way to think about it is, if people are being confused between your stuff and the famous stuff, it's a problem. For example, if people pick up the product and say, "Oh man, I love this Jeep shirt,"
or these red bottoms, these Louboutins. Yeah. There was just a case recently where Louboutin, and they prevailed for trade dress because people were painting the bottom of shoes red.
Oh my gosh, really?
Yes.
I didn't know about that.
And selling them. They did not call them Louboutins. They were not trying to pass them off as Louboutins, but Louboutin owns the red bottom as
shoes.
Trade dress.
Yes.
Tiffany's blue.
Okay.
Right?
Yeah.
And things like that. Things that that are distinct to the brand, you've got to be careful. You can be inspired, but you cannot copy.
Can I give a golf reference? Yes. Our friend Rich Rogers?
Yes.
The green jacket. The green jacket, the famous green jacket, from also a trade dress from the Masters.
The Masters.
Yeah.
I almost said the Majors.
Shout
oh my
Rich.
God, I would have embarrassed myself. Yes, but the green jacket, the NFL
Masters.
Hall of Fame, the gold jacket.
Yeah, exactly.
Right? All of that, those things are protected. And I'm going to pause really quickly just to fix the camera, but we can keep talking.
Okay, cool. So trade dress, actually, you can actually protect like product packaging. You can also protect what the design of the bottle or the design of the thing looks like. There's so many other ways you can actually, and these are all different ideas, right? Cool ideas. We talked about that earlier. If you have a cool idea, people like it, you should protect it.
You should protect it.
Yeah.
Right. I mean, and I love working with creatives because they're always creating, right? You dream about it. You wake up, you're jotting things down, you're sketching things, so my admonishment to you would be careful who you share it with, how you share it, on what platforms and in what situations, and, take the step to protect it so that, like I said, we're building on a firm foundation. So I want to ask you another question. ChatGPT.
Use it every day.
I do too. If it were not for ChatGPT, none of this would be happening.
Oh, man.
But what are some issues from an IP perspective with using things, generative AI like ChatGPT?
Okay. There's a lot.
A slew.
There's a slew of things. Well, first off, if you're working with confidential information, if you're putting in information that's confidential into the ChatGPT, you don't really know where that's going, right? It may not be confidential anymore because now you're sharing with other people. You just got to be careful with what any confidential information you're inputting into the prompts.
And just to be clear, that would be things like personal information about your employees, right? About your customers, names,
customer lists,
right? Designs, right? Specs, things like that you want. Poetry, exactly. Okay. Things that you want to keep protected. Because remember, how AI works is, we are getting a benefit out of it, right? Because it's helping us along, draft things, and that's great, but it's learning.
Oh, yeah.
From what we do.
Data sets.
That's how it works. So all of the information that you put into it is actually training the AI to be smarter.
Yeah.
Right. And so just like you get an output that includes information, we don't know where it came from. Your information could be included in an output for another user.
Nothing is free on the internet. There's a reason why, there's a free service. I mean, it's getting all your prompts and it's learning from your prompts. And even if you pay for the paid version, for the advanced version, it's, they're still inputting information that may not be kept, you don't really know where it's going. You know where it's going, but it's not kept confidential on your server. So that's something to think about. You got to be very careful with that on the company side.
Yeah. And I would say have a policy for your employees. If you're a business owner with employees listen, let them use it. Because it's going to help.
It's a great tool.
Yes.
It's a great tool.
But some parameters around the inputs, right? And what we're doing, how we're utilizing the tool, I think is important because some people just don't know.
Yes.
Right? It's like, I'm going to copy this whole list and put it in and ask ChatGPT to create a table and do all of this. Well, you got a good outcome, but output from it. But it also is, using that information in some way that is beyond your control that we don't even know. It's like a black hole of...
Yeah. And it's every generative technology, right? Yeah. So it could be, especially in the software space, you can actually, it's software. It will generate code.
Yep.
So you got to be careful of what you're asking it to generate. Obviously, it's a fantastic tool to help you write perfect code, but you got to be careful what you're prompting it to do because it's learning from your prompts. So
can you protect things that are created by generative AI?
that is a great question. That's actually probably one of the most controversial topics right now.
Absolutely.
So it's I guess it's still undecided. So the reason why that is to have copyrights to something, you actually have to be the creator or the author of something. So one of the reason why this is such a controversial topic is because when you're, for example, if you're using, I'm drawing a blank on the one to illustrate.
I would have been able to tell you.
Oh man, if you use a generative illustrator and you say create a pink elephant holding an umbrella, okay. If that image comes out with a pink elephant and an umbrella, that image is not owned by you. Okay.
Mm-hmm.
You haven't created that. You haven't created that actual image because under copyright laws, the person that creates it must be a human. And same thing with patent laws. So
Did you hear that? The person who creates it must be a human, and the courts have so far
have punted on that. Well, actually, in the patent world, the Federal Circuit, which is one of the courts of appeals in the patent world, they have decided that an inventor must be a human. So if the big challenge is now is that how we have inventions that are being, created by artificial intelligence, who owns the rights to that invention? Because, the software created it and it's not human. So.
And there was a case, and I'm looking for it now, on the copyright side.
Oh, yeah. Well, I could tell you, though, I think it was Zarna and the Dawn.
Yes.
Okay. So Zarna and the Dawn, that was a case where there was a graphical illustrator. She created this short story, and it had some images and some prompts. And so what she did is she was like a science fiction kind of story. She put some prompts. And the first prompt came up with the first image, and she said, "Oh well, change the change the sword to the left to the right. Put the fire out of the dragon on this place." And she prompted enough so she got exactly what she wanted. And the Copyright Office actually said that she didn't own the rights to those images. She was able to own the rights to the content, the actual written words of it, and the way where the words were positioned on the actual image, but she didn't own the rights to the actual illustrations.
Right.
Okay.
Because she wasn't the creator.
Yes,
the AI was the creator of the images. And so my suggestion is use it for inspiration.
Yes.
Right? You can absolutely use it for artistic inspiration. But if you plan to commercialize it and you want to protect it, I would be very careful about using the AI to actually generate what you're commercializing.
Yes. There's a whole bunch of lawsuits happening right now. Actually, Sarah Silverman, the comedian, actually just filed a lawsuit against, I think it was Google or Facebook, I want to say. And basically they're saying that, Facebook, what they use to train the AI models, and that's what they do, right? Is they have these software and they train, in order to generate your prompts, they use all these books, and they basically have the software read the books, and it learns from the books. Yep. And what they were saying is they actually copied the books in order to put that into the model. And I think it's going to be a lot of litigation. It's already started. It may settle out. I think the Supreme Court's probably going to have to rule on some of this. Yes. They're going to have some laws on the patent side. I think they're going to have to maybe change a little bit because, they're creating things. It's creating things, So it's a really gray area right now. Yeah. But I think your advice is fantastic as great tool, and I use it all the time to help me with documents and certain things. And I'll say, "Hey, give me a paragraph with this." You have to know what to do. That's the key. You have to know what to tell it to do. Yeah, that's the important part of it, and that's what you have to get trained for. So.
That's right. And Sarah Silverman, just to double back on that, is suing OpenAI, which they're the owners of ChatGPT, and Meta.
Okay, Meta.
Yep. So Facebook for copyright infringement.
There's a few others that have come through. I think they're coming down the line. We'll see.
Yeah, it's a hot area right now, and you will have to watch to see again. How case law and the regulators get after it, but it's a big issue because we're all using it in some way. So it's just trying to be as responsible as we can to make sure that at the end of it, we haven't lost value because we're not able to protect the
That's
things
right.
that we're creating. All right, so before we move into the segment that I'm most excited for, which is laws or naws.
Oh, I can't wait for this.
Is there anything else that you want to sort of touch on with respect to what you're seeing in your business, in any of the over any of the topics that we've talked about?
I think one I would say is, and we touched on this briefly, is for photographs, just because you see a photograph on the internet doesn't mean that it's free. I mean, it doesn't mean you can use it. We've probably seen lawsuits when, you copy a photo or you use a free photo on the internet for your website, or you hire someone's cousin's son on an internship to create their website. And now they use a photo that they pulled off the internet that was free.
Yep.
Make sure that when you're working with websites and you're posting photos and posting content, hopefully you create it yourself. But if you're getting licenses, make sure to keep copies of those licenses. Make sure you actually update the credit cards, because there's software out there that will go and find photos that are being used without permission.
Yeah.
And then they'll shake you down. They'll say, hey, you've been using this photo without our permission. We're going to file a lawsuit, or we'll take a small amount of like $5,000.
And you listen, and for some businesses, that's significant. Every penny is significant.
Absolutely.
So you want to make sure that you're not putting yourself in that situation.
Yeah. And it's also money, but also you gotta go to talk to a lawyer. You gotta,
Time,
there's this time, energy, and money. It's such a big deal. It's a waste of resources when it could be easily prevented by just paying attention.
Yeah. One other thing before we go into the game that we didn't touch upon that I think is so important, especially for this audience, is sort of brand names, right? I've started a business. I'm selecting a name. I cannot tell you how many people come to me. They've already decided, this is my business name. I've already registered it, and they think that they're good and they're moving forward. And I'm like, wait a minute. Wait. Did you ever check to see if the name is available for use? Before we move forward, before you make another investment, not only have you not registered it, to trademark it, but you haven't even checked to scan the environment to see if it's available to use in the jurisdictions in which you want to use it, right? What do you say to folks in terms of getting started, selecting logos, drafting logos and selecting business names? How important is it to not put the cart before the horse and really do the work to knock out searches and things like that?
Yeah, I think two things. The first one is you want to select a strong brand. Okay, there's actually strong brands and there's weak brands.
Yep.
There's reasons you may want to select a weak brand, but there's not many. Select the strong brand. The second,
and what makes a brand strong? A name strong?
Yeah, so a strong brand is a brand that's it's considered what's called arbitrary. It doesn't describe exactly what you're doing. So, for example, Apple for computers. Okay, the word Apple has nothing to do with computers.
Right.
Okay, great brand. Not a strong brand is podcast. Studios,
or the candy store, and you sell candy.
Yeah, energy drink for energy drink.
Right.
Difficult to protect,
Yes.
right? And you're gonna find yourself scrambling around trying to sue everybody because you think someone is using your brand and maybe they are using your brand, but they have the right to use it too.
Yes.
So pick a strong brand. The second one is, we want to make sure that the last thing you want to be dealing with is a trademark infringement lawsuit when you're trying to launch your brand.
Mm-hmm.
Big waste of time, money, energy. You spent 3 years developing this brand. And then all of a sudden you realize there's a company out there that, that's telling you stop using the brand because we own the rights to it. You spent all this time and energy developing the brand, and now you're faced with this. do a search, see what else is out there, make sure that maybe not only that you can register the brand, but that how it's not going to be an issue for the brand that you select with another brand.
Right. And, the one of the great examples I've heard of this is we're sort of picking names and, making sure it's arbitrary. As Derek said, is think about like Lemonade, like Beyonce's Lemonade album, right? Beyonce can use Lemonade in music because, well, she's not selling lemonade, but naming a lemonade stand Lemonade is probably going to cause some problems for you, right?
Yes.
So it's thinking about, whether or not it's going to cause confusion for folks when they're searching for you, when they're looking for your products and services in the market in comparison to other businesses doing similar things, right? And whether or not you have created something that it's not intuitive, right? It's not literal, like, right?
Yeah.
Like beauty shop,
or
salon.
Yeah, one of my favorite unique brands that's recent is Liquid Death for water. You heard of that brand?
I haven't.
Oh my gosh. It's water.
Right. See, I would think it's like liquid crack. Like I'm going to die.
It's water. It's water. Liquid Death. It's like a multi-million-dollar brand called Liquid Death that sells water. It's so unique and it's like everywhere.
Yes,
it's
unique.
So yes, unique. Liquid Death for water.
That's it. Is it unique? I love that.
Yeah.
All right.
Okay, we on to the game?
We're on to the game.
Okay, by the way, I have no idea what this game is about, so I am like so excited.
All right, so this is how it's going to work.
All right.
The game is called Law or Nah, as in no. So I'm going to read a statement.
Oh boy.
And then I need you to guess whether or not it is a real law or if this is completely fabricated. And you get 5 seconds to guess.
Okay.
All right.
There's some weird laws around here.
Oh my gosh. As I was doing my research for this segment, I was like, are you freaking kidding me?
Oh my gosh.
Like, this is real?
Yeah.
Crazy. All right. Are you ready?
Yes.
All right. The Sasquatch Law, which says Bigfoot hunters are subject to a felony punishable by 5 years in prison for hunting and slaying Bigfoot. Law or nah?
Nah.
It's a law.
No way.
It is a law.
Where is it from?
It is a law in the state of Washington. In fact, Skamania County, Washington passed a law in 1969 deeming the slaying of Bigfoot to be a felony punishable by 5 years in prison.
1969, huh? Okay. All right. Well,
it's a law.
That's kind of a useless law, I think. I don't know.
Well, I don't know. Maybe they have seen Bigfoot.
But you have to slay them too, though. So you have to actually bring the Bigfoot in and slay them.
Yeah.
So we fact checking these laws. No, I'm gonna wait. Let's keep going.
We're gonna say yes.
Yeah, we're gonna say yes.
All of these have been fact checked.
The answer
Derek.
is yes.
Don't challenge me.
TikTok is a source.
All right.
Oh gosh.
All right. The shoelace law.
Oh my god.
Which says any child between 5 and 13 years old seen without having their tennis shoes tied, their shoestrings tied, can be sent to juvenile detention. Law or nah?
That's gotta be a nah.
That's a nah.
Okay.
Okay.
Man,
that's a nah.
I was starting to lose faith in America with it. That was actually a real law.
Okay. Now this one is, this might be a little
50-50.
easier.
Okay.
You're
okay.
1 and 1. So this law says it's illegal to kill any animal, including raccoons, on a Sunday. Can you kill raccoons on a Sunday?
Can I ask for like a hint? Like call a friend? Like, should I call my friend from West Virginia and ask him?
Ooh, you don't know how hot you are right now.
Man.
You are close. Law or not? No phone a friend.
I'm gonna go law.
Virginia.
Oh, so close.
So close. Says it's illegal to hunt or kill any wild bird or wild animal, including nuisance species, on Sundays.
Wow.
Oh, and I'm sorry. I did misspeak. You can actually kill raccoons.
Oh, okay.
So raccoons are the exception.
Really?
Yes, I don't know why.
Oh my gosh.
I don't know why. All right.
I have a funny story, but I'll tell you later.
No, I want to know.
Okay, so my friend Justin, he's from West Virginia, awesome guy, and I didn't realize they hunted squirrels in West Virginia. I grew up in Trinidad, and they hunt squirrels in West Virginia.
Hey man, I did not know that about you. We'll get back to that.
Okay, so we were in law school, and one of his buddies, we went to the University of Florida, and one of his buddies came, and there's squirrels everywhere in Gainesville. And one of his buddies was like, he was like, every time he saw a squirrel, he was like going like this, and he couldn't believe how many squirrels there were. And my buddy Justin started laughing because he was like, there's no squirrels. There's not many squirrels in West Virginia.
I would vote for that. I'm sick of squirrels. And listen, in South Florida, the squirrels are aggressive. They like want to fight.
Yeah, they're big too down here.
Yes.
Yeah.
Yes, so, that's funny. That's funny.
Yeah, I thought it was kind of funny.
All right. So in this state, you can get married by proxy. There's a law that allows, for legitimate reasons for absence, that someone can stand in your place to get married for you. Law or not?
That's actually a really close one. I'm guessing somewhere out west. I am going to guess that it's a law, and I am going to guess that it's going to be probably Oregon.
So West Texas is considered West, right?
West Texas that's the West. That's Southwest. That's Southwest. Is
so
Texas?
It is Texas.
Wow. Okay.
In Texas, marriages by proxy are perfectly legal.
Really?
In other words, for things like military service, you can send someone to get married in your place.
Gosh, what about jail?
Oh,
There's a lot of jail marriages.
I mean,
gosh, think about that. That's legitimate, that's
a legitimate reason. I cannot.
Yeah.
But there is an alternative. So maybe that bars that because you can actually get married at the jail.
Really?
Yeah.
Oh, wow.
In some places, you can actually get married in the jail. In military, if I'm in Afghanistan, right? Like I can't physically be there in the country to get married. So maybe that's a little... I'm going to have to look into that, but that is a law.
Well, I'm 4 for 5 right now, but who's counting?
You are. Now, before we go on to the next one, you grew up in Trinidad.
Yes.
I was not aware.
Yeah, I'm a Trini.
You are.
Yeah, I'm a Trini.
I love it. Carnival?
Yes. Have you ever been?
I want to go.
You should go. It's the second largest carnival in the world.
I know. I've heard. I've seen pictures. But I got a little bit more gym time before I put on one of those fantastic.
Well, you have it's not till February, so you have a few.
Are you going?
No, I'm not going to go this year. But I will tell you that the reason why it's the best carnival is because you can actually play in the carnival. Okay, in Brazil, you actually have to go. You actually have to be part of the samba school.
Yeah,
and you have to kind of be allowed to participate. In Trinidad, they just you just pay a certain amount of money, you get a costume, and you jump up. Yeah.
I love it. Yeah. I love it.
So it's the best in the world.
Okay, I'm going to check it out.
Okay.
Trinidad for Carnival, maybe next year.
Okay.
All right. Let me see. Let me get another good one for you.
Okay. This is going to be going. All right.
You ready?
Hopefully this is not going to stump me because I'm going pretty good right now. I'm calling fact check on the first one, by the way.
Okay. Let me pull it out. That was Bigfoot, right?
Bigfoot, yeah.
Well, there you go.
Okay.
I don't want to distract you. In this state, it's illegal to hold public office unless if a person does any of the following. You ready?
Oh, man. So it's illegal unless.
No.
It's legal unless.
No, it's illegal. It's illegal to hold public office if you've done this. I misspoke.
Gotcha.
First.
Okay.
Fight in a duel.
Oh, my God. That's, oh, my gosh. Really?
Yeah. So if you've ever fought in a duel, you cannot hold public office.
Oh, that's a really great question. They have such crazy laws. I'm going to go nah.
It's a law.
Oh, no.
According to the Tennessee state constitution, it's illegal to hold public office if a person fights in a duel or knowingly be the bearer of a challenge to fight in a duel or send or accept a challenge for that purpose.
Oh my gosh, that's so unbelievable. Talk about archaic laws that are totally irrelevant,
Yes. Speaking of which, you ready?
Okay.
So now you are
A 4 or 6?
Yeah.
Okay.
Okay. So you need this one. You need this one. In this state, it is you could be guilty of a misdemeanor. If a man can be guilty of a misdemeanor if he knowingly seduces an unmarried woman using the promise of marriage.
I actually I thought I had the answer right away until you said the last one. Promise of marriage.
I like this law.
I'm gonna go law.
It is.
Yeah.
You want to guess the state?
New York.
South Carolina.
Okay.
That sounds about right.
Yeah.
Yeah.
That's kind of a fun law.
But I'm here for that law because you should not be promising women that you're going to marry them.
Yeah.
To have a little fun. And you know you're lying. I'm with South Carolina. Put them in jail.
I mean, you think about that. That actually someone had to like put that on the floor and they had to pass it. Someone got burned. Someone got burned, or their daughter got burned.
I was gonna say. I was gonna say. Somebody's father wanted to put it on the books.
Or mother. I mean, just.
Well, I mean,
jeez.
It doesn't say when the law was enacted because it might have told us whether it was more than likely a woman or a man. But there we go. All right.
That's a good point.
You ready?
Yes.
Okay. It is illegal in this state. You ready?
Yeah. Oh my gosh.
To order takeout or delivery from 2 restaurants on the same night and cancel the one over the other.
That's not a law. All right.
What's your score?
I like food too much.
I hesitated. That's why you got that one. I have to be more fluent on the NAS.
Okay.
All right. In this state, the state law stipulates that any person is guilty of a misdemeanor of the first degree if he trades, barters, buys, or sells infant children. That's actually not a hard one. You cannot barter in infant children.
Oh, yeah, that's the law.
Yeah, that was dumb. We know that. We know that. All right.
Oh, yeah. It's
You
going to
ready?
go. Yeah. I can't tell if you giggle when you giggle if that can be a law or just such like a ridiculous question, you know?
Every mother in this state that
state.
knowingly and secretly loiters about any building with the intent or home with the intent to overhear their children's conversation is guilty of a misdemeanor. And it says mother/parent. So it's not unique to mothers.
It's not. It's a nah. It's a badly written law.
It is a law or nah?
No.
It is a nah. So this is the actual law though. So the only thing that is inaccurate about this is that it's parents to children. Nosy people in Oklahoma are going to be in trouble because every person guilty of secretly loitering about any building with the intent to overhear and to repeat or publish the same to vex, annoy, or injure others is guilty of a misdemeanor.
Wow.
So listen, if you are in Oklahoma, mind your business.
Huh.
Mind your business because you may be charged with a misdemeanor.
That was a tough one.
Yeah.
That was a tough one. I definitely guessed right on that one.
All right. In this state, you need permission to exterminate a pigeon.
Oh my gosh. I'm just going to go law.
Yes. Though pigeons can be very anointing.
Yes.
You want to guess the state?
New York.
North Dakota.
Oh, man.
You need permission to exterminate pigeons.
I guess New York, you can kill them all over the place.
You can kill them all over the place. No person, firm, or corporation shall exterminate pigeons or other harmful wild birds without first having obtained a permit.
Wow. That is unbelievable.
So what's your score?
I think I got all but one.
Law or nah? Is Derek telling the truth? No, Derek, you did fantastic.
Thanks.
Fantastic.
That was fun. That was fun.
Laws or nas. That was a lot of fun.
Yeah, that was cool.
And that brings us to the end of the show, which makes me so sad because I've had so much fun.
Cool.
And I think you and I have to get another date on the book to do
Let's
this
do
again.
This. Yeah, for sure. I'm in.
All right.
Cool.
Well, thank you so much for joining LegalEase on Me. I'm your host, Malia. And here we make the complex legal things simple and easy to understand. And I'm so grateful to my guest, Derek Fahey with IP Plus
IP firm. Yep.
Plus IP
firm. Yep.
Firm for joining me today. You're fantastic. You want to give them your website?
It's www.plusfirm.com. You can find me on YouTube. Just Google Derek Fahey, Faheyesq, and you can find me.
And Derek, at one point, he and his family are going to escort me back to Trinidad for Carnival, and I'm gonna hold you to that.
All right.
We'll see you next time.
Bye, everybody.
Talking all things legally, LegalEase on me for entrepreneurs and content creators.